Hi, my name's Maria and I'm an associate here at Kemp IT Law. Today I'll be looking at the EU Data Act and how it interacts with the GDPR. The overlap between the two has led to a couple of common misconceptions. For example, that the Data Act only applies to non-personal data, and also that if personal data does fall within the scope, the GDPR no longer applies. Now, in reality, the Data Act has a broad scope. Its definition of data covers virtually all information generated by connected products and related services. And while much of this will be usage data, personal data is often also captured. So where personal data is within scope, the Data Act sets out specific rules around how that data must be made accessible, and also how it can be used and shared. And those rules apply regardless of whether the data is personal or non-personal. When it comes to the GDPR, the Data Act is very explicit about the interaction. For example, in Article 1, it states that the Act applies without prejudice to union law on the protection of personal data. And in Article 2, it says where data includes personal data, the GDPR continues to apply in full. This means that any processing or sharing of personal data under the Data Act must still comply with the GDPR requirements, including having a lawful basis and meeting transparency obligations. This is an example of so-called regulatory layering, which is becoming increasingly common and means that in practice, organisations may need to navigate multiple frameworks at the same time. And understanding how the two regimes fit together should be a priority for businesses considering their data governance strategies going forward. That's all for now. See you in the next video.